The subcommittee will come to order without objection. The chair is authorized to declare recesses of the subcommittee at any time. We welcome everyone to this morning's hearing on workplace protections for federal judiciary employees, flaws in the current system, and the need for statutory change. Without objection, the gentlewoman from Pennsylvania, Ms. Dean, will sit with the subcommittee for this hearing and will be permitted to ask questions of the witnesses if yielded time by a member of the subcommittee. Before we begin, I will remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of today's hearing. If you would like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I would also ask all members to please mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. I will now recognize myself for an opening statement. Good morning and welcome to today's hearing on workplace protections for federal judiciary employees, flaws in the current system, and the need for statutory change. The purpose of this hearing is simple. The more than 30,000 women and men who work for our federal courts deserve a workplace free from sexual harassment, discrimination, and retaliation. And yet, the federal civil rights statutes that protect nearly every civilian employee in the country, public or private, do not extend to them. This is by design. Policymakers in the judiciary have waged a decades-long campaign to stop Congress from remedying this grave injustice. As hard as it may be to believe, the same judges who are obligated to enforce our foundational anti-discrimination laws have fought off every attempt to extend those same laws to their own employees. The results are as predictable as they are devastating. At our subcommittee hearing on this topic 2 years ago, we heard about the tremendous, unconscionable impact it had on Olivia Warren, who testified about the abuse she endured as a law clerk and about how the system failed her when she reported that abuse. But these results are not inevitable. Thanks to Ms. Warren, her fellow witnesses, and many other experts and whistleblowers, we now have the Judiciary Accountability Act, bipartisan legislation that will give judiciary employees meaningful rights against workplace misconduct. While this legislation provides a pathway for real change, until it passes, judicial branch employees continue to be harassed and discriminated against with little recourse. Time and time again, representatives of the judiciary have told us that there isn't a problem and we should let them handle it themselves. But yet, time and time again, we hear from employees that the system is not working. Not only is it not working, but we continue to hear how the system worked against employees when they tried to report wrongdoing. Some of them, fearing retaliation, have chosen to remain anonymous. Others cannot speak because of the non-disclosure agreements the judiciary has shockingly forced them to sign. But 3 former judiciary employees are here today, willing to speak out: Mrs. Clark, Ms. Strickland, and Ms. Minor. I especially want to thank you for being with us today. And I know that it wasn't an easy choice, but your testimony brings us that much closer to giving every judicial branch employee the foundational rights that they deserve. You are making a difference, and we are forever in your debt. In closing, I want to read from the powerful letter Ms. Warren submitted for today's hearing, and it's a lengthy quote, so stick with me. Quote, "When I made the difficult choice to testify, I naively hoped that no one else would have to do so. I am in awe of the bravery of the witnesses today and heartbroken that more individual courage is required to continue to expose the depth and breadth of harassment in the judiciary. I hoped that the judiciary would take decades of calls to action seriously, especially in light of the repeated revelations over the past 4.5 years. But instead of meaningfully investigating a problem that every other workplace also faces and is under legal obligation to address, members of the judiciary prefer to minimize the problem, applaud themselves for establishing working groups, and write law review articles extolling purported progress. The inaction on this eminently actionable problem remains baffling and deeply painful. It is a stain on our judiciary, and today marks yet another sad and shameful day in a line of sad and shameful days. I hope that Congress will enact this bipartisan legislation and step in to guarantee basic workplace protections for the 30,000 employees of the federal judiciary. I hope that members of the legal profession, most of whom continue to remain silent and disengaged, will support this call to action. And I hope that one day our courts will be deserving of public confidence in the promise of equal justice to all, equal justice for all, end quote. Those are powerful words from an extraordinary, courageous, and powerful woman. It is now my pleasure to recognize the ranking member of the subcommittee, the gentleman from California, Mr. Issa, for his opening statement.
Thank you, Mr. Chairman. In this particular case, I want to associate myself, first of all, with all of your remarks. They help us set the gravity of what we're considering today and what we're hearing today. I want to thank our witnesses. This type of a situation of hostile workplaces in the past and likely in the present, and even with action in the future, must be a continued process of accountability. I am, more than many members, a believer in the separation of powers. I know that the 600 or so Article III federal judges are to enjoy a special deference from this branch and from the executive branch in order to ensure that they can maintain the independence that our founding fathers wanted them to have and gave them special standing to have. But they're not the only employees of the judicial branch. There are, in fact, thousands of employees. They are men and they are women. They are human. And humans do things wrong every day in the workplace, predictably. So as much as I believe that we have to think of and look at our constitutional officers, including the 9 that sit just a quarter of a mile from here, with some deference, we also have to look at this large amount of federal employees who employ other employees and who, as we will hear today, have, and perhaps a rare exception, but not nearly rare enough, have in fact engaged in conduct which has been both statutorily defined and federally adjudicated as wrong. And that last part is the part I most want to associate myself with the chairman on. The adjudication of what is wrong under these statutes should not be a different standard simply because you work in the Article 3 versus the Article 2 or Article 1. When I came to this body some 22 years ago, we had reduced the amount of times that we as a body, Congress, exempted ourselves. Over the last 22 years, we have further reduced that, and particularly when a process that we had to deal with workplace inappropriate behavior, including by members, was brought to light. It was brought to light with great embarrassment. we had basically paid employees to go away and kept quiet the misconduct, sometimes of non-constitutional officers, but sometimes of these constitutional officers in the House and the Senate. For that reason, the 30,000 employees that work for judges, for as law clerks, for other clerks, for federal defenders, court support staff, deserve this hearing and deserve thoughtful legislation to ensure that they are protected at least as well as they are in the other two branches. The harmonizing to the greatest extent possible needs to occur, and we need to do it, and this is the part where I show my deference, if you will. We need to do it in a way that is accepted by those federal judges, accepted by the 30,000 people who work over there as fair and showing appropriate deference to the branch having certain differences. But let's not exaggerate those differences. If a federal judge assaults someone, they need to be held accountable. By the way, this is not the only place that this committee needs to continue working. Another example is lawyers in the Department of Justice to this day refuse to have any disclosure to the Inspector General. They continue to consider themselves separate even when they have been accused of wrongdoing, including workplace harassment, including sexual harassment. So as we look appropriately at the chairman's work product, I think we look at it not as the final product, but not as a product to be cast aside. We will take action. We will take action on a bipartisan basis. Today we will hear from one of the witnesses about some of the progress that has been made, and I look forward to that. The question is progress something that can be verified and relied on, and in fact, does it take the place of a statute? I believe in some cases it might. Self-rule by the Article 3 branch is perfectly reasonable, but it has to be the equivalent of statute. It has to be accountable, and it has to be transparent. That last part is the part over and above what we're already dealing with here today that I'm most concerned about. I do not want accusations that might be related to keeping a judge off of a case or the like, which certainly, and all of you who have seen lawyers work and work very diligently know, lawyers can be so nefarious that they actually would try to have someone come forward that would bounce a judge. We have to protect against that. At the same time, we have to hold everyone, including these constitutional officers, accountable. So for that reason, I come here with an open mind toward not just the legislation before us, but other measures that we will need to. And again, I want to thank this panel of all women who come before us today to tell us what they believe needs to be changed and what happened to them in their lives. And with that, Mr. Chairman, again, thank you for this important hearing, and I yield back.
I thank the ranking member for his statement, and I'm now pleased to recognize the chairman of the full committee, the gentleman from New York, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, for holding this important hearing and for leading this subcommittee's ongoing efforts to investigate the persistent problem of harassment and discrimination in the federal judiciary and explore what Congress can do to address it. The United States courts are supposed to be a pillar of our democracy, built on justice and fairness, but it is becoming increasingly obvious that there's a crack in that foundation. While courts are charged with dispensing justice to the litigants before them, judiciary employees who are victims of harassment and discrimination are too often kept quiet, shut out of the very courtrooms they work so hard to support, and forced into Byzantine internal processes that effectively deny them the most basic procedural rights. It frequently seems that the court's internal processes work to the benefit of the accused rather than the safety of the accuser. Judiciary employees are virtually alone among employees of both the public and private sectors in being carved out from certain protections of the foundational civil rights laws. Racial discrimination, age discrimination, disability discrimination, religious discrimination, gender discrimination, and sexual harassment, all of these and more are prohibited by federal statutes that are backed by the strength and certainty of federal court litigation. An employee who has been victimized and who sues a harasser or abuser in court has the right to discovery, inspecting documents and examining witnesses, as well as the right to a neutral, disinterested arbiter to hear and resolve the dispute. These are only a handful of the many rights inherent to litigation that are meant to ensure plaintiffs' meaningful participation in the investigation and adjudication of their claims. These rights protect victims of discrimination and harassment and encourage the kinds of reporting and transparency that can identify hostile workplaces and stop patterns of abuse. Unfortunately, judiciary employees are guaranteed none of these rights. Employees of the third branch have no assurance that their harassment or discrimination claims will be addressed and their harms redressed in the same manner as nearly every other American worker. Fortunately, Congress can take action. We did so in 1995 and again in 2018 when we closed the loopholes that exempted employees in our own branch from the same statutes. The judiciary should have been included in those efforts, but such reform faced strong resistance from the leadership of the courts at the time, a position that has endured for nearly 3 decades. Meanwhile, the need to extend these basic protections to judicial branch employees becomes more urgent all the time. As this subcommittee's 2020 hearing exposed, harassment and discrimination remain serious problems within the judicial branch. Even more concerning, these problems have persisted notwithstanding the judiciary's attempts to address them with changes to its internal human resource policies, policies that are currently the only recourse of judicial branch employees when they have been victims of harassment or discrimination. That is why Congress must extend to them the protections of federal civil rights laws. What the judiciary is doing is not working, and Congress must intervene. Today, we will hear from a diverse panel of experts, advocates, and whistleblowers, all of whom have longstanding experience with the judiciary and the workplace misconduct suffered by judiciary employees. We will also hear from representatives of the judiciary, and I appreciate hearing their perspective. To the witnesses who are appearing today at their personal and professional risk, I want to thank you for your determination, your integrity, and your commitment to fair and equal justice. Today's hearing will serve as yet another piece of necessary labor toward maintaining the integrity and the independence of our third branch. But our work is not done, and we will keep working to give judicial branch employees the rights and protections they need and deserve. Thank you, Mr. Chairman, and I yield back the balance of my time.
I thank the gentleman from New York. And before we introduce our first panel of witnesses, without objection, I will enter.
Mr. Chairman, I just want to thank our witnesses for being here today. Thank you.
Thank you, Mr. Ranking Member. The first statement that I will enter for the record is the statement of Professor Aziz Huq, who is the Bernice J. Greenberg Professor of Law at the University of Chicago Law School. Professor Huq's statement concerns the constitutionality of congressional regulation of sexual harassment and related forms of misconduct within the judiciary. The second is a statement from Aliza Schatzman, who served as a law clerk to a judge on the D.C. Superior Court. Ms. Schatzman describes the abusive misconduct to which she was subjected while serving in that judge's chambers, the damage to her professional advancement and reputation that judge inflicted, and the lack of recourse she faced as she tried to report it. The third is a statement from Olivia Warren, who testified before this subcommittee in 2020. Ms. Warren builds on her earlier testimony and provides new additional information and perspectives on this committee's investigation and the Judiciary Accountability Act. The fourth, a letter organized by the Project on Government Oversight and signed by more than 60 organizations applauding the Judiciary Accountability Act's inclusion of a provision that would extend and codify best practice whistleblower protections for all employees of the judiciary. And I would also like to add a written statement from Michelle Cohen-Levy, who was counsel for one of our witnesses here today, Caitlin Clark, during Ms. Clark's employment dispute resolution process. And finally, I would like to add a letter from Diva Shaw, an attorney from Kecker, Van Nest, and Peters, which includes 2 anonymous statements from her clients, one from a former law clerk detailing the harassment she experienced while working at the federal judiciary, and another from a judiciary employee detailing the use of non-disclosure agreements in the judiciary's employment dispute resolution process. And today we will have 2 panels of witnesses. The first is a panel of individuals with experience in or testimony relevant to the federal judiciary. The second consists of representatives of the U.S. Judicial Conference. I will now introduce the first panel of witnesses. Caitlin Clark is a Georgia attorney who has worked in private practice and previously served as a law clerk for Judge C. Ashley Royal in the United States District Court for the Middle District of Georgia. Ms. Clark earned her undergraduate degree from the Georgia Institute of Technology in Atlanta, and her law degree, cum laude, from Mercer University Law School in Macon, Georgia. Welcome, Ms. Clark. Karen Strickland is a former assistant federal public defender who currently works in private practice representing indigent criminal defendants. She is a former law clerk for a state Supreme Court justice, a federal district court judge, and a federal circuit court judge. She was the recipient of a prestigious Supreme Court fellowship working in the administrative office of the U.S. courts. Ms. Strickland received her BA with highest distinction from the University of Vermont and her JD magna cum laude and Order of the Coif from Duke University School of Law. Welcome, Ms. Strickland. Laura C. Minor worked for the federal judiciary for 23 years in numerous capacities with the administrative office of the U.S. courts, including as the Associate Director for Program Services, the Equal Employment Opportunities Officer, and Secretary to the Judicial Conference. She is now retired after her over 2 decades of distinguished public service. Ms. Minor is an attorney who earned her BA from Georgetown University and her JD from Georgetown University Law Center. Welcome, Ms. Minor. And Sarah Marshall Perry is a legal fellow for the Edwin Meese III Center for Legal and Judicial Studies, part of the Institute for Constitutional Government at the Heritage Foundation. Her previous positions include Senior Counsel to Assistant Secretary for Civil Rights at the U.S. Department of Education and Senior Fellow for Education Reform at the Family Research Council. Ms. Perry earned her BS from Liberty University and her JD from the University of Virginia School of Law. Welcome, Ms. Perry. Ali Cole is the president and co-founder of the Purple Campaign and an adjunct professor for civil rights law at George Mason University. Prior to that, Ms. Cole worked in numerous capacities as a Hill staffer on political campaigns and as an attorney in private practice. Ms. Cole is nationally recognized as an expert on workplace harassment and discrimination and has been a contributor on numerous national news outlets. Ms. Cole earned her BA in History and Political Science magna cum laude from Tulane University and her JD magna cum laude from Harvard Law School. Welcome, Ms. Cole. Before we proceed with testimony, I would like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to to the subcommittee, and that any false statement you make today may subject you to 18 U.S.C. Section 1001. Please note that your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time frame, there is a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it means that your 5 minutes have expired. For this panel, we will have 5-minute rounds of questions after the witnesses' testimonies. Ms. Clark, you may begin.
Chairman Johnson, Ranking Member Issa, and members of the subcommittee, good morning. My name is Caitlin Clark, and I appreciate the opportunity to testify at this subcommittee hearing on protecting workplace rights for judiciary employees. At the outset, I'd like to emphasize that I am not here today to personally attack anyone I worked with in chambers. I am here to describe my experience clerking in the judiciary as an expectant mother. My sole purpose is to shed light on the inadequate protections for judiciary employees. The current protections failed me. I do not want them to fail others. In July 2019, I began what I thought would be a 2-year term clerkship for Judge C. Ashley Royal, a senior U.S. District Court judge for the Middle District of Georgia. During the first 6 months of my clerkship, I built great relationships with Judge Royal's staff, including his career clerk, who had worked for the judge for more than 15 years. She seemed to think very highly of my work, and I looked up to her as a mentor and a friend. By November 2019, Judge Royal offered to extend my clerkship for an additional 2 years, and by January 2020, I received a performance-based raise. But when I became pregnant with my second child, my hopes of building a career in the judiciary fell apart. After I announced my pregnancy to my colleagues in chambers, the career clerk's treatment of me changed. She became hypercritical of my writing, providing excessive and often contradictory feedback, which made it difficult to complete my work. If I asked her a question about her edits, she would belittle and berate me about the quality of my writing until I was reduced to tears. She never did any of this before I was pregnant. In early April 2020, a few weeks into the pandemic lockdown, Judge Royal called me to his house, which he had never done before. He expressed frustration about the pace of my work and brought up my pregnancy. I remember him saying something along the lines of, "While clerking may be a good mommy job, work still has to be done." Later that same day, I called the career clerk to discuss a motion I was drafting. She grew impatient, raised her voice, and said, "It's infuriating to me. I mean, you're pregnant." I remember that word, infuriating. She complained that my new baby was going to ruin her ability to enjoy her son's senior year of high school. I reported this conversation to Judge Royal the very next day, but he saw no need to intervene. And because clerks lack standard workplace protections under Title VII, I had nowhere else to turn. 2 months later, Judge Royal revoked the additional 2-year offer that he had made in November. Then, just 10 days before my daughter was born, he told me to clear out my office. Once my maternity leave ended, I would be terminated. I was shocked. I felt wronged. I had no recourse. At the time, there was no mechanism for me to file a complaint. In the days after my daughter was born, while I was, of course, overjoyed at her arrival, my wrongful termination and treatment in chambers was weighing on me. Fortunately, a few weeks later, the Middle District of Georgia partially adopted the Model Employee Dispute Resolution, or EDR plan, and allowed clerks to file misconduct complaints. But I quickly discovered this system was broken. Pursuant to the plan, I first submitted a request for assisted resolution seeking reinstatement to a comparable position and a positive letter of recommendation. Judge Clay D. Land, who had served on the bench with Judge Royal for nearly 20 years, reviewed my request. His final 2-page report stated that my claims could not be resolved to my satisfaction and a resolution could not be reached. I then filed a 23-page formal complaint alleging unlawful harassment, retaliation, and discrimination. Judge Randall Hall, the Chief Judge of the Southern District of Georgia, adjudicated my complaint. Like Judge Land, Judge Hall and Judge Royal are colleagues with nearly identical backgrounds. They have no incentive to police each other. I did not stand a chance in this forum either. I was denied the opportunity to conduct any discovery, cross-examine witnesses, or participate in a hearing. Unsurprisingly, Judge Hall ruled against me and found I had no claim. I then had 30 days to appeal the decision. On the day of the deadline, the EDR coordinator told me that, unlike all of my earlier filings, my appeal had to be submitted in person. This was in July 2021, during the height of COVID. Determined to keep fighting, I drove 3 hours to Atlanta with my newborn and toddler in the car and filed the appeal with minutes to spare. Just this morning, nearly 8 months later, the 11th Circuit affirmed the decision denying my claim. This decision is final. The EDR process is severely flawed. Law clerks are denied basic procedural protections and the independent evaluation that employees in virtually any other sector receive. Judges are left in charge of policing their own colleagues, allowing their conscious or unconscious biases to affect their decision. This stacks the deck against law clerks who are already extremely reluctant to speak out regarding misconduct given the power and influence of federal judges. Challenging a sitting federal judge and potentially ruining one's career is simply not worth the risk. I urge Congress to reform the system to allow for basic procedural fairness, to eliminate the self-regulation of the judiciary, to guarantee federal judiciary employees Title VII protections, and to protect those who speak out against discrimination from the threat of retaliation. Thank you.
Thank you. To my colleagues, I do want to acknowledge that those who will be giving testimony will be given a little time to be able to finish. I think you should know that out of courtesy to the victimization that they have experienced. So thank you very much for your understanding. And with that, I'll now turn to Ms. Karen Strickland. You may begin.
Chairman Johnson, Ranking Member Issa, and members of this subcommittee, thank you for the opportunity to testify. My name is Karen Devin Strickland. Before I complained of sexual harassment, I was a valued judiciary employee. I clerked for a judge on the Second Circuit and served as a Supreme Court fellow before becoming a federal public defender, my dream job since law school. But when I reported sexual harassment and sex discrimination by my supervisors, I was stonewalled at every turn as judiciary officials protected the perpetrators and punished me. I was forced to resign and lose my chosen career. I did everything I could to report the harassment, but the officials in charge of addressing workplace misconduct failed to take the most basic steps to address it and instead facilitated and aggravated the hostile working environment. Almost as soon as I began my job, the second in charge of my office, the first assistant, began targeting me with unwelcome attention that escalated into quid pro quo advances. When I told his supervisor, the federal defender, that he was behaving inappropriately and I was leaving work early every day to avoid being alone with him, the defender responded in part by comparing my harassing supervisor's authority over me to a marriage and ordering me to compromise with him. He then placed me more closely under my harasser's supervision. I reached out to the Judiciary's civil rights officer for guidance on my rights. She said the behavior I reported was classic sexual harassment. She said I was highly credible, but she candidly advised that it would be less risky to find another job than file a complaint because the cards were stacked against me and in favor of management. In an effort to help me, she reached out to a senior official in the administrative office who advised the defender to appropriately address the sexual harassment. Instead, the defender angrily berated me and said he was being blamed and attacked for something that was not his fault. Officials at the Judiciary's highest levels then intervened to protect the defender and block the efforts to address the harassment. I was taken off the track for advancement and denied a promotion for which I qualified, a culmination of the first assistant's efforts to punish me for rejecting his advances. The EDR coordinator, who was supposed to be advising me on my rights, told me it was not helpful that I reported discrimination to the administrative office because barriers go up and people are on guard. Ultimately, I did file a complaint under the Judiciary's Employment Dispute Resolution Plan. But the EDR process went off the rails, and for more than 6 months, officials took no meaningful action on my complaint. They denied my request to disqualify the defender from representing the office, even though he was a subject of my complaint. They also failed to conduct an appropriate investigation. They told me that my claims against the defender would not be investigated. My witnesses were never interviewed. The investigator, who the defender selected, admitted she was not trained or qualified. After the investigation ended, I was told I would not receive the report or its findings. Officials deliberately delayed taking disciplinary action, pressuring me to resign. During mediation, a mandatory stage of the process, the mediator told me that the defender was from a generation that didn't get sexual harassment, but officials wouldn't micromanage him. He said that the defender, who again was an accused person, was the decision maker. At this point, I reached out to the Judicial Integrity Officer, who had recently been appointed to advise employees like me. She confirmed that officials would not meddle in the office and could not order remedies because Article III judges do not have authority to manage federal defender offices. She called this issue jurisdictional. Having endured a hostile working environment for more than 6 months with no meaningful action on my complaints, having been subjected to a deeply biased and unfair EDR process, and having been told that no remedies would be ordered even if I prevailed, I had no choice but to resign. I accepted a temporary clerkship, a devastating step backwards from my dream job, in the hopes of mitigating any further attempts to ruin my reputation and career. Almost a full year after I raised my complaints, and several months after I resigned, the EDR coordinator informed me that disciplinary action was taken against my supervisors for wrongful conduct. I was still not told the investigation's findings or what corrective action was taken, nor was I offered the possibility of any remedies. My career was severely damaged, while the supervisors who discriminated against me stayed in their positions. For the past 2 years, I have been challenging the discriminatory and unfair EDR process in federal court under the pseudonym Jane Roe. The defendants argue that because I am not covered by Title VII of the Civil Rights Act, I have no right to review in a federal court, even under the Constitution. If their position prevails, then I will have absolutely no remedy for the denial of my right to be free from sex discrimination. Although I fear further retaliation, I am testifying publicly because you, as a co-equal branch of government, have the power to provide judiciary employees like me meaningful protections from harassment and discrimination. Thank you.
Thank you. Ms. Minor, you may now begin.
Thank you, Chairman Johnson, Ranking Member Issa, and distinguished members of this committee for inviting me to testify. My name is Laura Miner, and I worked in the federal judiciary at the Administrative Office of the United States for 23 years. During that time, I had direct insight into how the judiciary handles misconduct proceedings. Before I proceed, however, I would like to thank Ms. Clark and Ms. Strickland for sharing your experiences with us. I am sorry for what you were forced to endure, and I appreciate your efforts to address the misconduct that you experienced. When I began working in the federal judiciary, I had hoped to reach a point where employees did not have to testify before Congress in order to hold the judiciary accountable. But based on what I learned about the judiciary's response to workplace misconduct, although I am disheartened by your experiences, I am sadly unsurprised. I wish I could have done more, which is why I am here today. I am testifying today with the support of many of my former colleagues, my friends, and most importantly, my family. I am a wife, a mother, and the grandmother of 2 young girls, Naomi and Olivia. I care deeply about making the world a better, safer, and more just place for my granddaughters and others, which is why I am sharing my experience. I spent 23 years working in the judiciary in various positions that progressed in responsibility, ultimately serving as the Associate Director for the Department of Program Services, a position which reported directly to the Director of the Administrative Office. During my tenure, I spent 16 years as the agency's Equal Employment Opportunity Officer and became intimately familiar with the judiciary's struggles to deal with misconduct. In this position, I observed a process that discouraged people from speaking out for fear of retaliation, and a system that did not have adequate procedural mechanisms in place to keep employees safe. Employees often left the judiciary after facing misconduct or attempting to report it. They were almost always worse off because of their experience, more hurt, more cynical, and more worn down. Despite repeatedly flagging these issues for leadership, I felt my concerns were not heard. Although my written testimony provides more depth, I want to outline 4 specific observations about the judiciary's inadequate procedures. 1, complaints were frequently chalked up to bad management instead of discrimination or harassment, which minimized misconduct and allowed management to ignore patterns. 2, management would immediately question the veracity of any allegation and then fixate on questioning the complainant's competence. Employees who reported misconduct were very quickly labeled problem employees. 3, the lack of knowledge, training, resources, and awareness was glaring. Even when a complaint presented a clear case of sexual harassment, someone in management said there was nothing particularly attractive about the complainant, an irrelevant assessment used to diminish the misconduct. And 4, management lacked any interest in systemic change. I asked for transparency through statistics about reporting and workforce demographics. I was told that was not possible. I also asked about impartial appeals procedures and clearer guidance for employees. My concerns were dismissed. Eventually, despite over a decade of service as the agency's EEO officer, I accepted that I could no longer make a difference and resigned from that position. I continued working for the agency, was promoted soon afterwards, and retired on good terms and entirely by my own decision. The critiques I provide here and in my written testimony also apply to other reporting avenues in the judiciary. As the secretary to the Judicial Conference for many years, I became familiar with the reporting procedures for judicial misconduct and also the EDR plan described by Ms. Strickland and Ms. Clark. Although I am aware of the incremental changes that have been made to these reporting procedures since my departure, the testimony today confirms what I already know. Those changes are insufficient. Despite my faith and belief in the judiciary as an institution, I feel hopeless about the judiciary as an employer. In my opinion, the ineffective reporting procedures are merely a symptom of the larger problem, a culture that no amount of self-policing can fix. Although judges hold many of us accountable, they cannot and do not want to hold each other accountable. I urge this committee to consider the pervasive nature of the misconduct you've heard about, the many instances that go unreported, and the employees that are silenced through well-founded fears of retaliation or unwanted NDAs. My testimony does not come lightly, and my criticisms are not directed at any particular judges. I understand that you will hear from Judges McEwen and Robinson, for whom I have the utmost respect. I understand the difficulty and the gravity of their work, because I also tried for years to reform these processes. I pushed judges to bring the thoughtfulness and brilliance that they exhibit in the courtroom to addressing issues of misconduct for their own employees. Now I have no choice but to accept that the judiciary either cannot or will not shine a necessary light on this problem. Resolving this dissonance and guaranteeing basic workplace protections will require congressional action. Although the issues will not end with statutory protections alone, I ask you to provide judiciary employees with basic workplace protections for 3 reasons. First, these employees need concrete enforcement mechanisms instead of the current vague, biased, and ineffectual procedures. Second, legislation will help chip away at the judicial exceptionalism that unfortunately prevents any accountability. And third, external pressure will be more effective in changing the culture of the judiciary and making accountability the norm, not just in the courtroom, but in chambers and in our administrative offices, which have long been ignored. Thank you.
Thank you. Ms. Perry, you may now begin.
Chairman Johnson, Ranking Member Issa, members of the committee, thank you for giving me the opportunity to testify today. I also commend these brave women for sharing their stories. How easily 100+ years of women's progress can be forgotten in some circles. How quickly we are relegated in some circles to nothing more than our sex. The late Supreme Court Justice and feminist icon Ruth Bader Ginsburg once said that judicial independence is vulnerable to assault. It can be shattered if the society law exists to serve, does not take care to assure its preservation. The separation of powers demands that the 3 branches of American government operate separately from one another, and judicial independence is a foundational tenet of the 3rd branch. As the only non-political branch, the judiciary must be independent of the executive and the legislature to assure the absence of political influence. Congress has already empowered the Judicial Conference and the Circuit Judicial Councils to respond to complaints of judicial misconduct and prevent the legislature from meddling in the affairs and administration and workings of the judiciary, which is why this chamber's advancement of H.R. 4827 is concerning. As the Judicial Conference's year-end report from 2021 demonstrates, the judiciary is both aware of problems concerning the integrity of some judges and making extensive efforts to address them through wide-ranging reforms. In that conference's report, Chief Justice John Roberts noted that the Judiciary Working Group recognized the seriousness of several high-profile incidents, but found that inappropriate workplace conduct is not pervasive within the judiciary. Yet this bill would impose on the 3rd branch a commission on judicial integrity to oversee workplace misconduct and administer relief. Its membership would consist of executive appointees, recommendations from the EEOC, the U.S. Commission on Civil Rights, and other experts recommended by the Senate. The chair and vice chair would serve for 5 years and be appointed by the executive. The bill also calls for special counsel for equal employment and the establishment of an office for employee advocacy reporting to the House and Senate. Executive branch appointees overseeing the judicial branch, reporting to the legislative branch, is perhaps the penultimate separation of powers violation. This body's failure to seek input from the judiciary on this bill only proposes such an intrusion, and how it's telling. The bill also duplicates recently updated employee protections. A 2018 June report commissioned by the Chief Justice after sexual harassment allegations surfaced against then-Judge Alec Kozinski surfaced, leading to the federal judiciary's overhaul of its responses to workplace misconduct. The Judicial Working Group's 2018 findings and its 30 adopted recommendations led to an amendment of the Code of Conduct for judges, the Code of Conduct for judicial employees, and the Judicial Conduct and Disability Act rules. The Judicial Conference also created the National Office for Judicial Integrity and offices for circuit directors of workplace relations. In 2019, the Judicial Conference also revamped its employment dispute resolution plan and placed EDR coordinators at every local court. Judicial branch employees now have whistleblower protections. They have newly expanded protections against abusive conduct, that above and beyond discriminatory behavior, and they have confidentiality policies to remove barriers to reporting. If these changes don't evidence the judiciary's interest in and commitment to eliminating workplace misconduct, it's hard to imagine what would. Then there is the bill's backdoor affirmative action plan, an expansive diversity-driven effort in tension with both Title VII of the Civil Rights Act and the EEOC's explicit guidance, making it illegal for covered employers to make employment decisions because of race, color, religion, sex, or national origin. But this bill requires reporting on both hiring and interviewing individuals on those qualities alone. It runs afoul of the Supreme Court's assertion that diversity-driven hiring plans must be flexible enough to allow candidates to compete with other qualified candidates on a level playing field. Judges look for law clerks that share their judicial philosophy, who bring the sharpest minds to the tasks of interpreting and applying the law. To hamstring them by forcing them to adhere to faux diversity requirements does the federal judiciary and our entire legal profession a disservice. Whether by violating the separation of powers, duplicating new efforts addressing misconduct, or placing undue emphasis on candidate identities over qualifications, this body's foray into oversight of the third branch can look a little like a hostile takeover. Employment discrimination and harassment must be rooted out, and the judicial branch is no exception. Federal judge or not, no one is above the law. But the very premise of this hearing runs counter to available evidence and proposes a solution to the problem of discrimination that is constitutionally suspect. I look forward to welcoming your questions. Thank you.
Thank you, Ms. Perry. Next, we will hear from Ms. Cole. You may begin.
Thank you, Chairman Johnson, Ranking Member Issa, and members of the subcommittee. Thank you for calling this important hearing today and for the opportunity to testify. I also want to begin by thanking Ms. Clark, Ms. Strickland, and Ms. Minor on behalf of everyone who will benefit from your courage. Thank you for your powerful testimony. My name is Allie Call, and I'm the president and co-founder of the Purple Campaign, a nonprofit organization I started to address workplace harassment. I'm also an attorney and an adjunct professor at George Mason University, where I teach civil rights law. In the fall of 2017, I made the difficult decision to publicly share my own experience with sexual harassment as an 18-year-old congressional intern. It was only then that I learned that because I was an intern and not a full-time employee when my harassment occurred, I was not protected at all under existing federal law. That changed, thanks to members on this subcommittee and others here in Congress, when my story came out and I had the opportunity to work with lawmakers here to draft and enact the Congressional Accountability Reform Act. Today, however, there is still a segment of the workforce where employees continue to lack these important statutory protections, the federal judiciary. In his 2021 year-end report, Chief Justice John Roberts insinuated that such protections are unnecessary because workplace misconduct in the federal judiciary is not pervasive. With all due respect to the Chief Justice, the stories you just heard from the brave witnesses who testified before me today make clear that workplace misconduct is a significant problem in the federal judiciary and that the institution's efforts at self-policing have failed. In January of this year, the Administrative Office of the U.S. Courts sent a form to thousands of judiciary staffers asking if they had witnessed wrongful conduct in the workplace. After 40 people responded to the question and 34 of them, or 85%, answered that they had observed inappropriate behavior, the judiciary shut down the question, removed it from the survey, and claimed that the result was, quote, an unfortunate administrative error. But as Olivia Warren, the former law clerk who testified before this committee in 2020, explained, many employees do not feel safe reporting misconduct to the judiciary because they fear retaliation, a concern that is amplified by the fact that, unlike almost all other private and public sector employees, the people who work in the federal judiciary lack whistleblower protections under federal law. As you are aware, various federal laws, such as Title VII of the Civil Rights Act of 1964 and the Americans with Disabilities Act, exist to protect employees from discrimination and harassment at work. Until the 1990s, however, these laws did not apply to employees of the three branches of the U.S. government. But in 1995, Congress extended coverage of federal employment laws to its employees through the Congressional Accountability Act and to executive branch employees through the Presidential and Executive Office Accountability Act. To this day, despite its role as the institution tasked with enforcing anti-harassment and discrimination laws to other workplaces, the federal judiciary continues to resist calls to provide similar statutory protections to its own employees. In its 2021 annual report released just this week, for example, the Judicial Conference reiterated its opposition to legislative action on the grounds that it would interfere with the internal governance of the third branch. Last year, members of this committee introduced the Judiciary Accountability Act of 2021, the JAA, bipartisan, bicameral legislation that would provide strong statutory rights and protections against discrimination, sexual harassment, retaliation, and other forms of workplace misconduct to federal judiciary employees. Thank you for taking this important step. The JAA would finally give judicial branch employees the same anti-discrimination rights and remedies that private sector employees have had for decades and that employees here in Congress and in the executive branch now have as well. And it would protect whistleblowers by explicitly prohibiting retaliation against them and providing them with the right to sue for relief if they are retaliated against. On behalf of the more than 30,000 people who work in the federal judiciary today, I urge you to pass the JAA and ensure that federal judiciaries are guaranteed the basic fundamental right to work in an environment free from harassment and discrimination, and that nobody, not even the most powerful lifetime appointed judges, are above the law. Thank you.
Thank you. We will now proceed under the 5-minute rule with questions, and I'll begin by recognizing myself for 5 minutes. Ms. Clark and Ms. Strickland, thank you for your powerful testimony and for being here today. It might not seem like it yet, but I can promise you that you've made a difference in the effort to give judiciary employees the rights that they deserve. As I listened to you describe your ordeals, I kept thinking about the impact it must have had on you and how many other people probably have had similar experience who you are speaking up for today. I can think back in my own life to a time when I was your age and was the victim of mistreatment, not in any way similar to yours, but just the injustice that I felt at having been treated the way that I was treated and had no recourse, couldn't do anything about it, and it sticks with you throughout your career and throughout your life. So I know that many of us have had that same experience, not to equate it to what you all shared with us today. Ms. Clark, how did your treatment by Judge Royal and his career clerk affect you personally and professionally? And how did the profound flaws in the EDR process exacerbate that?
Thank you, Chairman, for your question. The discrimination that I faced while in chambers completely broke me. Mentally, emotionally, I've lost a lot of confidence that I'd gained in law school and while working in private practice. So much so, I'm not sure if the law is really something that I'd even want to continue. Professionally speaking, a clerkship with a judge can make or break your professional career. In my case, it broke my career.
Ms. Strickland.
Thank you for that question. This has been devastating for me, both professionally and personally. Before all this, I was a Supreme Court fellow. I was working in the administrative office. I was working for the Judicial Conference. I was highly respected and made lots of connections there. I was doing all these amazing things. But as soon as I made a complaint, all of that changed. And through the EDR process, I found that my name was dragged through the mud. I was vilified and ostracized. My character and integrity were brought into question. And the only thing that changed was that I had made a complaint. And now I don't know if my career will ever be the same as what it was. On a personal level, it's been humiliating, intimidating, and demoralizing. But when I think about the fact that with everything I had done, being a trained attorney, and everything I had accomplished, and I was still treated this way, it really made me fear and worry for how other people were being treated. And that is why I felt like I had to stand up for myself, and I have to fight for this. I have to fight for change so that no one else will have to go through what I went through.
Well, we appreciate you sharing this private pain with us, and I'm sure that it will have such a tremendous impact on those coming after you. And for you both, I know that as you move through life, you will be able to put this experience into perspective and see it as being a benefit to you. So please continue your hard work. I'd like to read from a letter we received from another judiciary employee who went through the EDR process, received a favorable decision, but then learned that the EDR policy did not empower the hearing officer to impose any remedies. Nothing changed except that the employee faced retaliation, and the fear of further retaliations has kept the employee anonymous. This is what that employee says, quote, "The EDR process made the limits of my power perfectly clear. Even if I am corroborated, believed, and validated, nothing will change. I did everything a person in my position could do, and still I accomplished nothing at all. These limits on my power are the logical outcome of the judiciary's EDR process, even and especially when the process performs as designed," end quote. Ms. Clark and Ms. Strickland and Ms. Minor, is there anything about those words that ring true to you, Ms. Clark? I'm sorry. Yes, well, I'm out of time, and I don't want to exceed my time, and so with that, I'm going to ask that you submit an answer to that question for the record, and I will now yield to the distinguished gentleman from Texas, Mr. Gomez.
Thank you, Mr. Chairman, and I appreciate you having this hearing. And it is, in preparation, it's been quite revealing. Having been a litigator in federal and state courts before my time as a state district judge, when I first heard this could be a problem years ago, because identifying, I mean, everybody knew what was going on in my judicial office as a state district judge. There was no privacy. And the people that worked for me were not attorneys, and they didn't seem to have a problem expressing their displeasure with things that went on. But then after getting to Congress, right off the bat, we had 2 federal judges that we impeached, one from Galveston, who had actually sexually assaulted one of his staff and actually harassed others. And so my naivety was blown away pretty quickly. Of course, another was impeached. He didn't seem to think there was a problem since he appointed people to lucrative appointments, that why not have them contribute to his son's tuition when it came due. So anyway, so I appreciate all of you coming up. And you know, I know it gets personal. There's nothing pleasant about coming forward. So thank you. That takes, obviously, courage. But like I say, I didn't realize it was a problem until I got to Congress. So I want to make sure that people that are victimized have a proper opportunity not to have to go through what Ms. Clark, Ms. Strickland, y'all endured, and others we've heard about. I do have concerns about giving authority to the executive branch in areas of investigating or making decisions on, sexual harassment allegations. That seems to be contrary to, the balance of power that we have, the checks and balances. I was not aware that Judge Roberts had taken the position until I saw what the testimony was. I would have hoped, for heaven's sake, the Supreme Court would be supremely sensitive to making sure that our courts were acting with propriety. Ms. Perry, what's your thought about the executive branch having any role in enforcement?
I have grave concerns about it, and the fact that the chair and the vice chairs are all appointed by the president and serve for a period of 5 years. That puts a lasting imprimatur of the executive on the federal judiciary, and there are no judiciary employees that participate themselves on the proposed Commission on Judicial Integrity. And in fact, the newest iteration from the judiciary workforce has created the Judicial Office of Integrity. So those two are duplicative already. But beyond that, there are 3 executive appointees that serve at the president's request for 5 years.
But if you got a Chief Justice that doesn't see that it's a problem, and I would see the same thing if Congress is supposed to be investigating, and not just investigating, but actually sentencing judges. But if you got a Chief Justice that doesn't see there's a problem, where's the answer? You'd have to have buy-in from the Chief Justice to make it work. What's the solution?
So I think that's a great point. And the Chief Justice mentioned the fact that there was a problem with certain high-profile cases. He did not, however, find it to be—
Well, that was generous of him.
Correct. And he did not find it to be—
Being sarcastic.
He did not find it to be an endemic problem. And as a result of all the modifications that have been made for these past 4 years, I think reading his year-end report on the federal judiciary, he is hopeful that those changes, once they are allowed to take root, will prevent some of this conduct in the future.
Well, my time's expired as well, but for the Chief Justice to be hopeful doesn't give me a lot of hope to avoid these kind of circumstances for the future. hope is not enough unless you've got the structure in place where judges know they too will be held accountable. I just want to do it in a way we don't lose the balance of power, the checks and balances, but no judge should ever have people that feel like they cannot complain about truly inappropriate conduct. But I, again, appreciate all of you being here. You've obviously given this tremendous thought. And again, Johnson, thank you for having the hearing.
Thank you, Judge. Thank you, Judge Gomer. I will now turn to the gentleman from New York, Mr. Nadler, for 5 minutes, the chair of the full Judiciary Committee.
Thank you, Mr. Chairman. Ms. Minor, I want to thank you for being here today and for lending your voice and experience to this hearing. I also appreciate your call for giving judicial branch employees enforceable rights and meaningful protections against discrimination, harassment, and retaliation. As I listened to your testimony, I was struck by how important it is that you decided to come forward now after your many years working at the AO. So I'd like to ask you this, Ms. Minor, why now?
Thank you. I would say that this moment found me. I retired, and I thought that I had done all that I could do when I left the administrative office of the United States courts. And then someone reached out to me and said, I'm still having issues, and can you give me any advice based on your experience? And ever since I left the AO, people have reached out, both from the courts and from the AO, and asked, what can you help me with? What can you tell me about what has been going on? And I offered my experience to them. And as this evolved, I honestly felt like it was a gift to be able, in retirement, to say this, because I didn't feel like I could say it in a very loud and public way when I was working for the judiciary. I'm just like the other people on this panel. I tried internally, I made comments, I brought issues up, but I certainly never brought them to Congress or to anybody else. I tried from the inside to make a change. And so I think this is a moment and a gift to me.
Thank you. One of the most concerning things we hear from the judiciary is that Congress cannot provide judicial branch employees with statutory civil rights and meaningful protections because it would somehow infringe on judicial independence. But I'd like to read from or quote from a letter to the subcommittee from constitutional law professor Aziz Hook, who writes that, quote, neither text nor precedent support a pertinent limit, unquote, on Congress's power to legislate in this area. Ms. Call, does Congress have the authority to give employees of the judiciary enforceable rights and protections against discrimination and harassment?
Thank you for that question. I want to start by saying, of course, the separation of powers between Congress and the federal judiciary is an important component of our constitutional system. In particular, the decisional independence of the courts is vital. We would not want Congress punishing the judicial branch for rendering a decision that it disagrees with, for example, but that is not what we are talking about here. We are talking about legislating around the basic administrative functioning of the courts, which is something that this subcommittee has already done in various ways, this Congress, and something that has been historical practice since the beginning of the Republic. The necessary and proper clause of Article 1 of the Constitution gives Congress broad powers to legislate around the functioning of the courts in this way, and so it would be a significant departure from both constitutional law principles and also from historical practice to conclude that the JIA does so in any inappropriate way.
Thank you. Ms. Clark, it sounds to me like the EDR process, which is supposed to give employees rights and protections, protects the perpetrators instead of the victims, and was actually being used against you. What would you say to a judiciary employee who is considering using the EDR process?
Thank you for your question. I would tell them that it's most likely a waste of time. You know, I did every avenue, the three different ways you can complain. I asked for informal advice, I did the assisted resolution, and I also did the formal complaint, all three of which were fraught with hoops to jump through, roadblocks, discretionary rules made against, not in my favor. And so I would say that it is a waste of time.
Thank you. Ms. Strickland, what about you? Is there anything you'd like to add?
Yes, thank you. I think it's a really difficult decision. In my case, I was specifically told that the process would be stacked against me and I would be better off finding another job. And frankly, I think that was really good advice, and that's probably true. But I also understand the absolute crushing burden of feeling like you can't come forward and you can't stand up for yourself. And so really, at the end of the day, what we need is some sort of process where people actually have basic fairness and a basic impartial forum where they feel like they can be heard and adjudicate their claims. And so I suppose I would tell that person it's a personal decision. Hopefully they can get personal empowerment out of it, but I wouldn't expect anything from the process itself.
Thank you. My time has expired. I yield back.
Thank you. We will now hear from the gentleman from Wisconsin, Mr. Tiffany, for 5 minutes.
Thank you, Mr. Chairman. Thank you to all the witnesses for appearing before the subcommittee today. I share the same sentiment as my colleagues on both sides of the aisle, that there is no place for workplace misconduct and hostile work environments. Ms. Call, you heard from Representative Gohmert, as well as the chairman of the committee in regards to the encroachment on one of the branches of government. And it is a deep concern of us, and I think Representative Gohmert began to, I believe he touched on it quite well. You know, we've been having hearings in this committee where we've seen abuses by the FBI where they're now going after parents for just attending school board meetings, participating in school board meetings, where there's been even talk by the executive branch of using the Patriot Act against those parents. We've seen the abuse of the FISA courts, which is clearly has separation of powers concerns for us. And I believe the chairman touched on this a little bit, but do you have any concerns with how this bill is written about that separation of powers that we think is so important? And we really have to be neutral arbiters up here, you know, in terms of looking at the information and making the best decision to protect the freedoms and liberties of people in America. Does this bill bring up any concerns for you in regards to this?
Thank you for the question. So I endorse this bill as it is written, but I understand and would be happy to talk further with you and other members of this committee about specific concerns you might have. I will say, with respect to the involvement of the executive branch, I just want to point out that the commissioners are removable by the Judicial Conference, so I think there are appropriate checks and balances built into the bill as written. I also think it's important to remember that Congress has legislated with the executive branch and with itself in a way to provide employees with these basic statutory protections, and that without those statutory protections, there is no equivalent recourse. You know, the idea that this is duplicative of the judiciary's own internal EDR process is not, it doesn't make sense when you think about the way that Congress has legislated around this issue vis-a-vis the private sector, its own employees, and the executive branch. So, for example, it would be to say that a private sector company's employee handbook or HR department is duplicative of Title VII of the Civil Rights Act of 1964. That's simply not the case. We've decided there needs to be federal legislation and statutory rights for those employees in the event those procedures fail, and that's what the JAA does.
Do you think there's been any improvement made in the last few years?
I think that the judiciary has taken important steps in the right direction through its EDR plan, but I think those are not equivalent to statutory rights that the JAA provides.
So, Ms. Perry, you talked about reforms. Have they been substantive?
They've been extremely substantive. These have been going on for 4 years, and each year the Chief Justice has recognized that there have been more and more changes that have been added. And in fact, some of these changes, again, from the last few months have not yet taken place. In fact, the Judiciary Workplace Working Group's report just came out yesterday. They have not only highlighted all of the changes they've made within the past few months, but also have made additional recommendations that I think are a sufficient substitute, an appropriate substitute for this bill, which goes too far in intervening in the internal workings of the judiciary.
So you say it goes too far, and the question that I've been asking, so you believe that this is giving too much power to the executive?
I do, absolutely. Not only because there are appointees from the executive branch, but because there was no input solicited from the judiciary itself. There are no judiciary members, save those who are confirmed by the Senate or by the House. So the judiciary itself, in a piece of legislation that will directly affect its operations, notwithstanding even the employment disputes, but then allowing the Congress to ultimately dictate diversity requirements for the hiring of staff or law clerk when, in fact, judges want to hire people with the same judicial philosophy. It really is a 1-2 punch. The effect of the executive and the legislature within the judiciary is problematic for me. I think the judiciary is heading in exactly the right direction. In fact, the EEOC Commission has called it a model response, saying that they wished more governmental agencies, more branches, took this level of extensive reform.
Thank you, and I yield back, Mr. Chairman.
Thank you, sir. And we will now turn to the gentleman from New York, Mr. Jones, for 5 minutes.
Thank you, Mr. Chairman, for holding this vital hearing today. And thank you to our witnesses for courageously sharing your traumatic experiences with such heinous harassment and discrimination that you've experienced, and of course to the many women across the nation who have had similar experiences, who have spoken up to demand an end to this unacceptable status quo. You should never have had to do this work, but we are all grateful that you are doing this work. I want to make a few observations before getting to my line of questions. I have found this discussion of an opposition to the bill under consideration, the Judiciary Accountability Act, on some theory that it would violate separation of powers to be entirely incoherent. It actually undermines the system of checks and balances that our framers wanted, to have an entire class of people, in fact, 30,000 or so within the judiciary, who are unable to vindicate their constitutional rights. So this isn't just about the administration of the courts. We're talking about Title VII rights meant to implement constitutional provisions. And that is one of the various things that this bill under consideration would do. It would follow the recommendations of several experts in this area by broadening Title VII of the Civil Rights Act and, of course, the Americans with Disabilities Act to cover the 30,000 judicial branch employees. So I want to be very clear on that. I also think discussions about the Patriot Act and, respectfully, Ms. Perry, affirmative action to be red herrings in the context of a hearing about workplace discrimination and harassment. And I would ask that folks who have raised those red herrings to really have some perspective. Ms. Cole, the leaders of the federal judiciary assure us that they understand the crisis of sexual harassment in our courts and that they are committed to addressing it. Yet they insist that the best way to protect judicial employees from abuse by their bosses is to trust those bosses to end the abuse themselves. And no one is more insistent that the status quo is working than Chief Justice Roberts. As you noted in his 2021 year-end report on the federal judiciary, Chief Justice Roberts wrote briefly about sexual harassment and discrimination. The Chief Justice spared just two paragraphs in his 9-page report to address this crisis, fewer than he wrote about William Howard Taft. What little the Chief Justice did have to say did not inspire confidence. Instead of acknowledging that untold numbers of judicial employees have experienced abuse that in any other workplace would be unlawful, he simply reiterated the conclusion of his workplace conduct working group, that misconduct is, quote, not pervasive in the judiciary. But we know that nothing could be further than the truth. And instead of committing to whatever it takes to guarantee the rights, safety, and inclusion of all judicial employees and hold perpetrators accountable, our nation's top jurist merely expressed his hope that judges themselves would weed out, quote, incivility and disrespect. I don't want a system of accountability where we rely on the Chief Justice of the Supreme Court to be a person of good conscience and to do something like what we are seeing these witnesses today ask. That is not a true system of accountability. Ms. Cole, what message do you hear when the Chief Justice of the United States can only be troubled to write 2 paragraphs on sexual harassment and discrimination in his year-end report?
I find the repeated assertion from the Chief Justice and from the federal judiciary that workplace misconduct is not pervasive to be very problematic. I think, as you heard from the testimony today, we know that these public stories are only the tip of the iceberg. Most people who experience harassment do not report it, even through internal channels, let alone come forward publicly as these brave women have done today. And a major reason why people don't come forward is because they believe that their institution won't take them seriously. So when that is repeated over and over again, that the judiciary itself does not believe it has a problem, that's only going to further discourage people from coming forward and lose trust in the process. So I think it's important to create these statutory rights as a way for Congress to say, we believe that this is a problem. We believe that if the judiciary doesn't take the steps it needs to internally to protect you, that you all will do so.
Thank you. In closing, I feel compelled to say to our courageous witnesses today what Chief Justice John Roberts would not, which is that sexual harassment and discrimination, like what you and countless colleagues of yours have experienced, was not isolated incivility. It was the systematic violation of your civil rights, rights that the law should guarantee to everyone, rights that the law will guarantee to everyone when we pass the Judiciary Accountability Act this year. Thank you, and I yield back, Mr. Chairman.
Thank you. We will next hear from the gentlelady from North Carolina, Ms. Ross, for 5 minutes.
Thank you, Mr. Chairman, and to the ranking member for holding this very important hearing and taking this situation seriously. I also want to thank all of the panelists for your powerful and personal testimony. Under current law, the more than 30,000 employees of the federal judicial branch are not protected by the foundational federal statutes that prohibit workplace discrimination, harassment, and retaliation. 30,000 employees. This lack of protection and accountability is especially concerning given that federal judges are giving lifetime appointments to the bench. Unlike members of Congress, federal judges do not run for re-election. There is no built-in mechanism to keep them in check. As a result, bad actors in the federal judiciary have a license to act inappropriately. And as we have heard today, the judiciary does not maintain a sufficient internal process for holding these individuals accountable. Moreover, the federal judiciary is one of the many fields in which men outnumber women, and again, for their lifetimes. This imbalance creates a culture that is resistant to change and is overly tolerant of toxic workplace practices like those we've heard described today. It is critical that we pass legislation to establish protections to ensure oversight and accountability within the judicial branch. No one is above the law. My first question is for Ms. Strickland. I'd like to hear your reaction to how the Judicial Conference describes its dispute resolution process. Here is what they say. Our employment dispute resolution system has long provided judiciary employees enforceable protections against all the same conduct covered under Title VII of the Civil Rights Act of 1964, the Age Discrimination Act of 1967, as well as the Americans with Disabilities Act of 1990 and the Rehabilitation Act of 1973. Based on your experiences, are any of the protections in the EDR plan actually enforceable in federal court?
Thank you for that question. With all due respect, the idea that these protections are actually enforceable is completely inaccurate. In my experience, they were not enforceable through the EDR process itself. I was told that by multiple high-level judiciary employees that they would not be enforceable, even if I went to a final hearing. And now that I am in litigation, the judiciary defendants have taken the position that none of these rights are enforceable in federal court, even if this process goes off the rails.
Thank you. And Ms. Clark, I think it can be hard for people who haven't worked for the judiciary to understand what it's like to work there. Can you explain why judicial branch employees are especially vulnerable to discrimination and harassment?
Yes, thank you for your question. Judicial employees are extremely vulnerable for several reasons, but what sticks out to me the most is the power disparity between you and the judge that you work for. You know, like I said earlier, that they can make or break your career, and so you know people don't want to come forward with this information for fear of retaliation.
Okay, great. And to both, we only have 37 seconds, Ms. Clark and Ms. Strickland. Briefly, why is the lack of transparency an impediment to navigating the internal processes?
Because it creates a culture of silence, because it makes people feel alone and compartmentalized, and it intimidates them from coming forward.
Ms. Clark.
Yes, I had the exact same experience, so yes, I would agree with Ms. Strickland on that.
Thank you so much, and Mr. Chairman, I yield back.
Thank you. I must compliment the gentlewoman from North Carolina for her efficient use of 37 seconds.
And the witnesses.
And now we will hear from the gentleman from Wisconsin, Mr. Fitzgerald, for 5 minutes.
Thank you, Mr. Chair, and thanks to the panel. I apologize up front if I'm redundant here in the questions because I'm running between two different things right now. Ms. Perry, in addition to the creation of the Commission on Judicial Integrity, HR 4827 creates an Office of Judicial Integrity and an Office of Special Counsel for Equal Employment Opportunity, and an Office of Employee Advocacy. With each office being led by individuals appointed by the Commission, would any of these new offices be duplicative of workplace protections and resources already available to the judiciary?
Yes, Representative. And the first of those, the Commission on Judicial Integrity, absolutely duplicates the Judicial Office for Integrity that was created 2 years ago during the height of some of these reforms that have piggybacked on one another. There has been a continual evolution towards stricter and stricter regulations, more enhanced protections for judicial employees, whether that's enhancement of the Judicial Code of Ethics, the Judicial Conduct and Disability Rules, or the Code for Judicial Employees. There have been a number of expansions. So first, the office itself duplicates an office that was just created 2 years ago. And I'm sorry, Congressman, what was the other question that you asked?
Well, the follow-up would, and maybe you talked about this already, which again, I apologize, but there was an issue in the ability of judges to select law clerks.
Yes, that as well goes to specifically the diversity reporting requirement that's required under the Judicial Accountability Act. In other words, not just those who are hired, but those who are interviewed, disaggregated by all protected categories under civil rights law, placing an undue emphasis on individuals to be hired strictly because of these identifying characteristics in violation of Title VII. Law clerks are chosen for their judicial philosophies, their suitability to the task of interpreting and applying the law. So it is, as Mr. Jones said, a red herring in this situation. It is something that's not required. It doesn't go to the issue of solving the workplace dilemma, and it is duplicative of other protections in federal law.
Thank you very much. Thanks to the panel, and I yield back, Mr. Chair.
Thank you. We will now turn to the gentleman from Arizona, Mr. Stanton, for 5 minutes.
Thank you very much, Mr. Chair, for holding this important hearing. Before I begin, I will yield 1 minute of my time to the Vice Chair of our committee, Congresswoman Dean.
Ms. Dean is recognized.
I thank you, Mr. Chairman. I thank you for this hearing, and I also thank you, Representative Stanton, for yielding for just 1 minute. I want to offer a special thank you to every woman on this panel and many others out there who find the strength and courage to speak up. First, I want you to know I truly wanted to be with you today, and but for my current positive COVID diagnosis, I would be there with you. You know, I was a young trial attorney, and I intimately recall the authority and the power a judge could hold over his courtroom, and I'm old enough to say his more often than hers. Although I did not clerk, I could only imagine from your testimonies what may happen in the confines of a judicial chamber. I wanted you to know that I spoke with Eliza Schatzman, a Pennsylvanian, a lawyer, a young woman who shared with me her experience within the chambers and without. She recalled the feelings of isolation, the silent treatment, the different treatment from her male co-clerk. Eliza described the current state of judiciary as uniquely insulated from scrutiny, unaccountable to the public, based on the testimony we've also heard here today. And I'd have to agree, this must change. Thank you, Mr. Chairman, for recognizing that. I recognize, too, that her full testimony has been entered into the record without objection. And so I just simply thank the subcommittee for working to ensure that no other woman is subject to harassment in the workplace without recourse. Representative Stanton, I yield back.
Thank you very much, Congresswoman Dean, and wishing you a swift and full recovery from COVID. And thank you to our witnesses who have testified so honorably at today's hearing. I join my colleagues in condemning the outrageous behavior and the appalling circumstances that you have endured in the workplace. It's clear to me that reforms are necessary and essential to better protect the rights of those employed by the federal judiciary. And your testimony here today is a key to spurring positive action. So thank you for speaking up, speaking out, and for sharing your important stories. I have a question for Ms. Minor. You worked at the AO for many years, including as the AO's Equal Employment Opportunity Officer. Can you speak to the culture in the judiciary as it pertains to addressing workplace conduct? What was the attitude at the AO when it came to investigating these types of complaints?
I appreciate the chance to speak to this because I think it's actually the key to why involvement of the legislative branch is so important. The general attitude and the culture in the AO, quite frankly, and in the judiciary as a whole, is that judges are the last word on everything. And so while there were people within the judiciary who tried to address the issues, at the end of the day, if the judges were not willing to be accountable to each other or to hold each other accountable, all the systems in the world don't really make a difference. What is happening now is nibbling around the edges of things. I will tell you that. I told someone once, I heard a chief judge say to me, I'm not going to meddle in anybody else's business in chambers because when I'm not the chief judge anymore, I don't want anybody meddling in my business. Now, that's not every judge, but there were enough judges who felt that way that it's very clear to me that without real cultural and structural change within the judiciary and oversight, the judiciary will want to do the right thing. It can't do the right thing. Nibbling around the edges will not change that culture. And it certainly did not change it at the AO. I am still in contact with many friends and colleagues who are very clear with me that nothing has changed. Thank you.
Right now, there's a series of voluntary policies and procedures instead of enforceable statutory protections. You somewhat answered in what the answer you just gave, but why do you think those kinds of internal policies and procedures will fail if they are not backed up with enforceable rights? This is for Ms. Minor.
I guess I will repeat what I said, which is those are nibbles around the edges. The culture and the structural barriers that exist within the judiciary will make those fail, as they have for so many years. My personal story is that I came to the judiciary in 1994, and the very first job I had was responding to the Congressional Accountability Act, which originally included the judiciary. They successfully got themselves out from under that. I spent 2 years traveling all around this country, educating people about equal employment opportunity, and then it was over, and everybody went back to business as usual. And I fear that that is exactly what will happen this time unless this committee moves forward and puts the statutory protections in place for judiciary employees. Thank you.
Thank you very much. I yield back. Thank you, Chairman.
Thank you. The gentleman from California, Mr. Issa, is recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank you all for your indulgence. Unfortunately, the classified briefing on Iran gets in the way of everything because you can only have the White House when you have them. Ms. Perry, you obviously spoke very eloquently about the separation of powers and our limitations. Let me start by asking a question. If you set aside 600 Article 3 judges and presume that we judge them based on their good behavior, and you look at the entire rest of the 30,000 employees, for all practical purposes, is there any reason that we should not consider their protection separate from the question of those constitutional officers?
I think factually, as long as we're satisfied that there is an endemic problem, I think there's nothing preventing us from taking that into account. For example, the Administrative Office of the Courts was at one point under the jurisdiction of the Department of Justice. So it's created by Congress from 1939, but operates distinctly separate as an administrative agency tasked with assistance of the federal judiciary. But those particular protections, again, as applied to federal judges themselves, I find to be more problematic than against those who are employees of the federal judiciary.
Okay, and then switching to the other side, Ms. Minor, because you've operated in that oversight role, isn't it, and I don't want to lead you unfairly, but isn't it fair to say that we lack today here in this body the transparency of the conduct of those 600 or so federal Article 3 judges that would allow us to proactively know whether or not their behavior was good? You know, the standard under which we are charged to impeach them and remove them is obviously it's high crimes and misdemeanors, but it's really good behavior. And what you have all talked about today is in some cases, a clear absence of good behavior. Do we have the transparency today, or would you say that all or part of the reforms we're talking about are, in order to get transparency sufficient to know what's going on in a way that we can meet that responsibility? And I'm making the assumption for a moment with our Ms. Perry that we set aside the Article 3 judges for a moment and say we judge them under our constitutional limitation. But then how do we amass that information, if you could opine on that?
Well, thank you for leading me in the direction. My sense is that you have very little transparency right now as a branch into what happens in the judiciary. In fact, what I generally find and it has happened over and over the years, is that whenever an issue comes up, they circle the wagons and they keep everything inside. And there is also something about the structure of these courts, and I think people sometimes miss this. We have a lot of small courts in our federal judiciary where there are only 1 or 2 judges, sometimes 3, where it's almost like a family. In fact, the judiciary describes themselves as the judiciary family.
Even San Diego does that. But yes, the eastern wing that only goes a couple of days a week really is quiet.
So as a result of that, what you have is what I think you find in families, quite frankly, and that is, if there's an issue, let's keep it in-house and let's deal with it. And so very little comes out about what is actually happening. So I think there is a huge problem with transparency right now, and if there are things in the JAA that will help create that transparency, I think that's critical to trying to address these issues.
Now, let me ask one final question, if I could, Mr. Chairman. The judiciary, and particularly Chief Justice Roberts, has opposed anything that would be the equivalent of an inspector general, even one that he would create and appoint. When we look at the AO and we look at the cases that we dealt with here, isn't it the absence of that process, an advocate for finding wrong, which is what inspector generals do, the absence of that in the AO, and as a result, the absence of that as one more availability for 30,000 non-constitutional officers that work there, isn't that inherently a flaw that we need to look at to create that, whether we do it through this legislation or something else, with or without the support of perhaps the justices? When we look at, and I use the AO because I think it is a good example of something that is not inherently our Article 3 judges directly in that separation of powers.
Yes.
Okay. Then, Mr. Chairman, with your indulgence of giving me additional time, I just want to close and say I want to thank all of our witnesses today. I particularly, I'm going to look at my former member of our branch and the protections that we need to always give in this branch are something that's on our mind because Mr. Johnson and I, and for that matter, the chairman and others, we lived through that period. We were embarrassed by what we discovered and made the decision to legislate on ourselves. And lastly, I apologize that we often leave that third branch out of deference and sometimes to the detriment of having to go back as we are here today. So I just want to thank you all, and thank you, Mr. Chairman.
Thank you, Rep. Issa, and I'm sorry to trample upon your closing statement. I had agreed before you got here with Mr. Gohmert that I would allow him, in the spirit of bipartisanship within which we've held this hearing, to ask one last question that he wanted to pose to all of the witnesses. And so with that, Representative Gohmert.
Yeah, and I do appreciate that opportunity. And I want to be clear, I have no problem legislating a solution here. We got every authority to do that. And my constitutional law professor that I lost last year, I grew to love, not when he was my professor, but he used to say, there's only one court that doesn't know its existence to the Congress. Congress brought all the other courts in to being except the Supreme Court, and we can take them out but there is a delicate balance. So my one question to each of you is very sincere. Obviously, hope is not enough as we share that concern. If you could change one thing to help tweak the legislation to providing appropriate accountability, which we clearly don't have yet, but observing the need for the judiciary independence. And Ms. Minor, I would like to ask that question to you and get each of your buy-in. You've all obviously given this a great deal of thought. You're bound to have seen something else. I wish it did this.
Well, I'm here today because of the experience I had in the judiciary, not because I'm an expert on the JAA.
But that makes you an expert.
So I think I'll cede my time over to the rest of the experts on the panel here.
I'm not an expert either, but I think what I will say is that it was very clear from my situation that these people believed that they faced absolutely no liability exposure, and so there was no incentive for them to do the right thing. And so I think the most important thing, in my personal opinion, about this legislation is providing a cause of action so that people can pursue their rights.
Ms. Clark?
I'm no expert either, but I will say that the most important thing about this piece of legislation is that it'll create an independent special counsel to investigate claims of misconduct. Independence is something that virtually, every person in corporate America gets an independent arbitrator of their claims of discrimination, and so I feel like that is very, very, very basic. That's the least we can do. So,
Thank you. Ms. Cole?
I think the core of this legislation is about providing these basic statutory rights to employees that they currently lack. Ms. Strickland's case is a great example. She has tried to bring her claim in federal court. The judiciary knows that this is typically how employees whose internal processes fail them find relief. It's what they do under Title VII every day. And in her case, the judiciary's lawyers are arguing that that the EDR plan provides no property right under the Fifth Amendment, and employees who've tried to bring these cases under Title VII have had their cases dismissed by the EEOC for lack of jurisdiction.
Back to circling the wagons, actually.
Yeah. So I think, the fact that there is no remedy, as I said earlier, the idea that the EDR plan is duplicative of statutory rights is not the way Congress has seen this issue in any other workplace. So I think providing those fundamental rights will go a long way, both toward allowing for greater remedies, but also just sending a message to employees, like circling back to my own experience as an intern, being told you have no rights under federal law does not engender a lot of faith in your institution.
Ms. Perry?
So if I have to pick one thing, Representative, I would want to eliminate the Commission on Judicial Integrity, knowing that the judiciary has already established that precise mechanism within its own body. And I would also like to see this chamber hold regular hearings from the Administrative Office of the Courts on what workplace conduct, what workplace study and data is transpiring, what they are seeing at the ground level, and how they're responding to it, either annually or biannually, so that we can be assured fully that they are responsive and they're not shrouded behind a veil of secrecy.
Thank you. Mr. Chairman, thank you.
Thank you. And I want to thank all of the witnesses. Ms. Perry, you've been a magnificent defender of the status quo. I may not agree with what you have to say, but I admire your professionalism, so thank you.
Thank you, Chairman.
Ms. Minor, you have been on the inside, and you've seen what happens, and you've tried to make a difference while there, but your efforts were not at the right time, or the time was not right for you in that position, but yet things have changed. You've retired, and you don't have to stay in your comfort zone as many would. You decided to come out and say what you know, and we deeply appreciate that. Ms. Cole, you are, as a young 18-year-old suffering discrimination, you could have been snuffed out in terms of your contribution to the legal profession, but instead you've become the phoenix. And so you're a shining example to Ms. Clark and Ms. Strickland, who have just begun this journey. Without you all, we would not have a foundation for this hearing. So you all have been the foundation for this hearing, and we thank you for your courage in coming forward. And with that, I would also like to recognize some unsung individuals in the, not courtroom, but in the hearing room. The pro bono attorneys who represent Ms. Clark, Ms. Strickland, and Ms. Minor. For Ms. Minor, we have Diva Shaw and Aaron Meyer, both from the firm of Kecker, Van Nest, and Peters. Thank you all for being here. For Ms. Karen Strickland, we have Jenny Sook Gerson and Cooper Strickland, who are here. Thank you all for your pro bono work. And last but not least, for Ms. Caitlin Clark, we have Mr. Roscoe Jones Jr. and also Ms. Greta Williams, who is a repeat offender here today. They are from the firm of Gibson Dunn, and we appreciate you all's pro bono representation. And with that, we will now proceed to our second panel of witnesses. And we will allow you to collect your belongings and depart while I have a phone call right quick. So I'm going to step down. I will now introduce the witnesses on our second panel. Judge M. Margaret McKeon. I hope I pronounced that correct. McCune. Judge Margaret McCune has served as a circuit judge on the United States Court of Appeals for the Ninth Circuit in San Diego, California since 1968. She is chair of the Ninth Circuit Committee on Workplace Environment and a member of the Federal Judiciary Workplace Conduct Working Group. Prior to joining the federal bench, Judge McQuinn was a partner in private practice and served as a White House Fellow under President Carter. Judge McQuinn earned her BA from the University of Wyoming and her JD from Georgetown University Law Center. And I know I would be catching glances of disapproval now if we were in the courthouse, but welcome, Judge McKeon. I hope I've given you some, I hope I've pronounced that name somewhat correctly. And Judge Julie Robinson is a senior judge from the District of Kansas, where she has served since her appointment in 2001. Judge Robinson was the first African-American to be appointed to the District of Kansas bench and served the federal judiciary with distinction in several capacities, including as a member of the Federal Judiciary Workplace Conduct Working Group. Before her appointment to the federal bench, Judge Robinson clerked for bankruptcy Judge Benjamin E. Franklin, worked as an assistant U.S. attorney for a decade, and herself became a bankruptcy judge. She earned both her undergraduate and Juris Doctorate degrees from the University of Kansas. Welcome, Judge Robinson. Before proceeding with testimony, I would like to remind all of our witnesses that you have a legal obligation to provide truthful testimony and answers to this subcommittee, and that any false statement you make today may subject you to 18 U.S.C. Section 1001. Please note that each of your written statements will be entered into the record in their entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. There is a timer that should be visible on your screen. That should help you stay within that time limit. Judge McKeon, you may begin.
Thank you. Chairman Johnson, Ranking Member Issa, and members of the committee. I am Judge Margaret McEwen, a United States Circuit Judge for the Ninth Circuit. And I note, Mr. Chairman, that you've come the closest of anyone pronouncing my name correctly, so thank you for that. I'm accompanied today by Judge Julie Robinson, United States District Judge for the District of Kansas. We are both members of the Workplace Conduct Working Group, established at the direction of Chief Justice Roberts, who in 2008 called for swift action to address workplace concerns. Thank you for the invitation to be here today on behalf of the Judicial Conference of the United States. The federal judiciary is committed to the well-being of its employees and to an exemplary workplace by ensuring a safe, respectful, and professional environment, free from discrimination, harassment, abusive conduct, and retaliation. Over the past 4 years, the working group has, in consultation with judiciary employees, law clerks, outside experts, and interested groups, recommended more than 30 changes to the policies and practices and procedures of the judiciary, all of which have been adopted by the Judicial Conference. The judiciary is also committed to ensuring that every employee has a clear avenue to obtain confidential advice, report misconduct, and seek and receive remedial action. Our written testimony describes many of the transformative actions that have been taken. I will briefly highlight just a few points. To begin, judiciary employees are protected from the same conduct that would violate 10 enumerated employment laws and policies, including Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, the Americans with Disabilities Act, the Rehabilitation Act, and whistleblower protections. The judiciary also provides expanded protections beyond these statutes against abusive conduct, based on the working group's finding that while inappropriate conduct is not pervasive, incivility, disrespect, and abusive behavior is more common than sexual harassment. Second, we have improved the workplace protections and procedures. Revised model employment dispute resolution plans are in place for the courts and for federal public defender organizations. Codes of conduct confidentiality obligations were updated, and they now remove barriers to reporting and emphasize the responsibility of judges and judiciary employees to take appropriate action upon learning of potential misconduct. Confidentiality provisions for law clerks were also revised to clarify that confidentiality does not prohibit the report of misconduct by judges, supervisors, or any other judicial employee. Rules under the Judicial Conduct and Disability Act clarify that discrimination, harassment, abusive behavior, and retaliation are cognizable misconduct, and added that a bystander judge's failure to report is also cognizable misconduct. Third, we have streamlined our procedures and made it easier for employees to seek confidential help and report misconduct while enhancing impartiality and protecting confidentiality. A network of trained professionals, including local, circuit, and national workplace specialists, are now available to provide confidential guidance and advice. We took to heart the EEOC's advice regarding the importance of having multiple avenues for reporting. We have expanded the paths for employees to raise concerns to choose the options that best fit their needs: informal advice, assisted resolution, or formal complaint. The incorporation of informal advice and assisted resolution has provided additional opportunities for reporting, and that's been indicated by the increased use of these processes and has allowed issues to be resolved more quickly. The directors of workplace relations, a judiciary innovation, report that more time is spent on confidential informal advice than anything else, and that these interactions involve a range of workplace issues, not just harassment. These confidential conversations provide for a variety of interventions that would not have been possible if employees were uncomfortable coming forward or limited to filing a formal complaint. Fourth and finally, we have emphasized training at all levels to ensure employees are aware of their rights and protections. EDR training, orientation, management training, and educational programs all contribute to transforming workplace culture. The positive effects of the protection and improved processes have already begun to take hold. The judiciary looks forward to even greater improvements that will further enhance the fairness, dignity, and respect with which we treat our employees. Mr. Chairman, I thank you and look forward to questions from you and the committee.
Thank you, Judge McEwen. Next, Judge Robinson, you are recognized.
Thank you. Chairman Johnson, Ranking Member Issa, Chairman Nadler, and other members of the committee. Thank you for the invitation to appear today to discuss workplace conduct matters in the federal judiciary. I share my experiences and views not only as a member of the working group, but also as a chief judge who served from 2017 until last December. As you have heard and read in our testimony, the judiciary is committed to an exemplary workplace and has taken action to improve workplace protections and the dispute resolution process. These improvements are the result of leadership, which is a key imperative for creating a safe workplace. Chief Justice Roberts demonstrated decisive leadership from the top by creating the working group. In addition, engaged leadership by chief judges and court unit heads sends a powerful signal to our community that everyone must support a safe and civil workplace. While many protections and procedures have been improved, the judiciary's work is not done. The working group has proposed additional recommendations that would strengthen policies and procedures, expand communication and training, and improve our measurement of our progress. The working group, for example, recommends a nationwide climate survey disseminated at regular intervals to all judiciary employees to assess the workplace environment and also to provide insight into the prevalence of workplace conduct issues and the impact and effectiveness of the improvements we have made to our policies and processes. In addition to leadership, a continuing focus has been to build confidence and trust in the changes that have already occurred and that will occur. Building that trust requires a clear explanation of how we are addressing workplace misconduct. We have done so with training and awareness at all levels, with judges, with judiciary employees, locally and nationally. The working group recommends strengthening annual EDR training. A related recommendation to expand outreach and engagement will help courts fully understand employee concerns. Another element of trust is regular reporting. The working group recommends including in our data collection information and data related to informal advice contacts. We also recommend issuing an annual judiciary workplace conduct report. Confidence is further enhanced by ensuring fair and impartial procedures. The working group is further proposing that in addition to existing recusal requirements, the judiciary's policies be enhanced to specify that an employee complaint must be overseen by a judge from outside the court from which the complaint originated. Another key imperative for creating a safe workplace is to have effective policies and procedures written in clear and plain language. You have heard or read in our testimony many improvements in that area. The working group has additional recommendations to enhance policy. These include assessing incorporation of additional monetary remedies as part of the EDR complaint process, and developing a system for regular review of the judiciary's workplace conduct policies in order to ensure comprehensive implementation across courts and circuits. We also recommend adopting an express policy regarding romantic relationships in the workplace where there is a supervisory or evaluative relationship. Solutions that work must account for the unique culture and governance of a particular workplace, which in the case of the judiciary includes a dispersed, regionalized governance structure. Individual courts at the district and circuit levels possess significant administrative autonomy, including authority to address workplace conduct matters. The reforms instituted since 2018 took careful account of the judiciary's decentralized governance and culture. We have now established a system that empowers employees to seek advice and guidance from experts at the local, regional, and national level, and empowers them to seek resolution through informal advice, assisted resolution, and/or formal complaint procedure. This is more likely to be used and to be more effective than a single national oversight body. We believe that the judiciary's response to workplace conduct concerns is succeeding locally at the circuit level and nationally. And while the judiciary has made significant strides and with expeditiously so, some changes do not occur overnight. Thus, this is a continuing effort, and we expect some cultural changes will need time to take root. That said, we do not condone misconduct at any level. The judiciary recommends that our strategy for an exemplary workplace continue on its current course without sweeping legislative overhaul. Thank you, Mr. Chairman. I look forward to questions from you and the members of the committee.
Thank you, Judge Robinson. We will now go to questions, and I will proceed under the 5-minute rule with first deferring to the gentlelady from North Carolina, Ms. Ross, for 5 minutes.
Thank you very much, Mr. Chairman, and thank you to the witnesses for testifying and for your service. I just have two questions. The first question is, I don't know if you listened to the testimony from Ms. Clark and Ms. Strickland, who were in the panel before you came on, but they spoke about their experiences with persistent harassment and with the inability to secure meaningful redress through the judiciary's internal system. We also received an anonymous statement from a former law clerk echoing the same difficulties. After hearing about these witnesses' testimony today, and knowing that the system really is failing them, how can we protect them in the future from this kind of abuse and lack of redress?
Thank you for the question. Let me first say that I very much appreciate the courage of the witnesses who've come forward to testify. The judiciary has taken this call to action seriously, not only today, but before. But I think it's important to focus on what has changed in the judiciary since many of the processes described by some of the witnesses. So we acknowledge that our work is not done, but we have provided new avenues for reporting. We've provided trained investigators, trained mediators, and trained advisors in the judiciary. It is a question not only of rules and procedures, we understand. It is also a question of culture. And we have worked hard not only with the judges, but also with the many employees of the judiciary to understand that things have changed, that this is not the past, that we too, the judiciary, like others who took the wake-up call from the Me Too movement, that we can't look just at the past, but we have to look forward. And so we've outlined in our written testimony the very many things, along with the recent report, that the judiciary has done. So the work is not done, as Judge Robinson indicated. We have further recommendations that we trust will be accomplished.
My second question is that the Judicial Conference has vocally opposed the expansion of federal civil rights laws to judiciary employees for at least 25 years. How can the Judicial Conference reconcile opposing granting their own colleagues the basic protections that they apply and interpret every day for the rest of society?
The Judicial Conference has not opposed our employees, our 30,000 plus employees, having the same protections that all other people enjoy under Title VII and all of the other employment statutes, age-based, disability-based, et cetera. And in fact, our employees have those same protections. The difference, of course, is that
they can't enforce them.
They are enforceable. They are not, our employees do not fall under Title VII, but our employees have a formal EDR process that allows them to seek judicial adjudication much earlier in the process than, for example, the two other branches of government, where those employees have to go through an administrative process, get exhaustion, perhaps be subjected to formal mediation before they can even seek a judicial resolution. Our employees, the very first step, should they choose to, can seek judicial adjudication of their complaint.
With all due respect, it didn't appear that it was as fair a process as it would be for a private litigant from the testimony that we received today. Thank you, Mr. Chairman, and I yield back.
Thank you, Congresswoman Ross. The chair recognizes himself for 5 minutes. Judge McCune, Judge Robinson, thank you so much for joining us today and for your incredible service to our nation. Judge McCune, beginning with your confirmation in 1998, you served on the Ninth Circuit alongside Judge Alex Kozinski. In 2017, Kozinski resigned in the wake of numerous reports that he had coerced women who clerked for him into looking at pornography with him, made sexually degrading comments about them in front of other judicial employees, referred to them as, quote, slaves, and engaged in other forms of verbal and physical harassment. According to a number of survivors, Kozinski's misconduct was an open secret across the Ninth Circuit. Did you ever witness Judge Kaczynski act inappropriately in any way towards any of his employees?
No, sir, I did not.
Let me be clear. Until the allegations became public, you never had any reason to think that your colleague, Judge Kaczynski, acted inappropriately toward any of his employees?
No, I did not. I do not think it's fair to say it's an open secret. I served with Judge Kaczynski over many years. I would acknowledge that he is an unusual personality in his approach, but it was not until those brave individuals came forward and told our chief judge and various reporters about these allegations of harassment that we had first heard about those. And I might add that as soon as those allegations were made, our chief judge filed a misconduct complaint against Judge Kaczynski. He then called me before Judge Kaczynski had responded or resigned and said he wanted a workplace committee, that we should start our work immediately, which we did. And then Judge Kaczynski resigned.
Thank you, Judge. And so in the nearly 20 years you worked with him, you never even heard a rumor that he had done anything like that, correct?
I don't know if I would say I've never heard a rumor. I've just heard rumors about antics, but not about the kind of allegations that these individuals came forward with.
You also served on the Ninth Circuit alongside the late Judge Stephen Reinhardt from 1998 until his death in 2018. Last Congress, when this subcommittee held its first hearing on sexual harassment and discrimination in the federal judiciary, Olivia Warren courageously testified about how Judge Reinhardt harassed and abused her during her clerkship for him. More than half of Judge Reinhardt's clerks acknowledged this behavior and supported Ms. Warren's testimony. Did you ever witness Judge Reinhardt act inappropriately toward any of his employees?
I did not, and I was certainly shocked to hear the allegations, and I, of course, credit those allegations to the witness. As you know, Judge Reinhardt died within 3 months of Judge Kaczynski's resignation, and I believe that the clerk in question was a clerk at that time, and the workplace procedures that we've now instituted and put in place did not exist at that time.
Judge, thank you, Judge, and I want to get to those procedures, but just want to clear something up. So until the allegations became public, you never had any reason to think that your colleague, Judge Reinhardt, acted inappropriately toward any of his employees? Had you heard a rumor like you had heard about Judge Kaczynski, for example?
No.
Okay. Judge McCune, the Ninth Circuit never completed a comprehensive investigation of the harm that Judge Kaczynski or Judge Reinhardt inflicted on the people who worked for them, even after witnesses publicly described the sexual harassment and discrimination that those judges perpetrated. Why didn't that comprehensive investigation occur?
The undertaking that we went forth immediately was quite comprehensive. First of all, we took a survey of our 6,000 employees to find out their views, their comments, the pervasiveness or otherwise of harassment and discrimination. We reached out to law clerks. We held focus groups. We also reached out to outside groups, such as the Law Clerk Accountability Group.
Judge, I'm so sorry to interrupt. I just want to clarify. Isn't it true that your disciplinary jurisdiction terminated upon Judge Kaczynski's resignation and Judge Reinhardt's death, respectively?
That's true, but under the new procedures, the Judicial Conduct and Disability Committee has very express authorization to now do a look back. We didn't have the authorization, but we went ahead and we did what we considered an important look back to see what had happened and why.
Thank you so much. So I just want to be very clear as we conclude. No law expressly authorizes the Judicial Conference to promulgate the Model Employment Dispute Resolution Plan. And to me, and I think to many of the folks who have testified today in this extended hearing, that is a deficiency. And so I just want to urge some perspective around that, and of course to thank, again, our incredible jurists for their participation in today's panel. And with that, this hearing has concluded.